This is Daybreak, and thank you for staying with us. The hashtag on X is Citizen Daybreak. The SMS code is 22422 at Citizen TV Kenya and at Ayub Abdikadir. With me in studio this morning is the Migori County Senator Eddie Okech. Good morning, Senator.
Good morning.
Lovely having you here on the broadcast.
Thank you.
A lot has developed since we last had you here.
Sure.
And a lot to talk about. And also the 49th President of the Law Society of Kenya, Counsel Advocate, that is Nelson Harvey, is with us in studio. Good morning.
Bogatov.
It's lovely having you gentlemen here on the broadcast. We had invited the Gatanga lawmaker Edward Morio Wakili, and we're still awaiting for confirmation. Nonetheless, the show proceeds here. I understand that he will not be with us here on the broadcast this morning. Nonetheless, we take a look at the highlights of what has happened since yesterday, starting off with the outrage of a police phone spying expose and the American government yesterday expressing concern over the loss of privacy and the rule of law around rights of a private citizen. Its ambassador Meg Whitman had said, and it needs to be respected in democracies, according to her. This is the shock which greeted the story which was revealed of how police have been colluding with telecommunications firms to irregularly access call data and location records that are used to track and capture suspects, with the American government now denouncing the abuse of mobile phone users' right to privacy. We'll be talking about that. First, let's begin with the determination made by the Supreme Court yesterday, and the National Treasury had scored a big win after the court overturned the nullification of the Finance Act of 2023, allowing the government to continue the collection of taxes using the laws. The full bench of the top court ruled that if that Parliament adhered to the required legislative process of public participation and concurrence when enacting the law. And we begin on that note. And Counsel Harvey, you tweeted hours later that the Supreme Court is the court of last mistake. What do you mean by that?
Well, in the hierarchy of decision-making from the High Court, Court of Appeal to the Supreme Court, courts are bound to make errors. The only unfortunate aspect of an error that is made by the Supreme Court is that that error becomes the law and is not capable of being set aside by either an appeal or review thereafter. Look, the Supreme Court as the apex court is not entirely supposed to base its decisions on what it considers to be the law alone. It is a policy court. It's supposed to read the mood of the people of Kenya. And what is the mood of the people of Kenya? After the High Court and the Court of Appeal declared the Finance Act 2023 unconstitutional, you saw the reaction of the people. They resonated with it. Thereafter, when the people of Kenya took over Parliament on the 25th of June 2024, the President was compelled to reject the Finance Bill 2024. Now, if the successor of the 2023 Act has been rejected by the people, on what basis will the Supreme Court find it to be constitutional? It's on that basis, therefore, that we term the Supreme Court to be the court of last mistake. Last mistake.
And in your view, would it have been wise had the judges had individual judgments regarding the determination that they have made and the consenting or dissenting opinions regarding what was before them in making the determination that they had delivered yesterday?
Doubtful. Since the departure of Chief Justice Willie Mutunga, the Supreme Court has been unanimous in its mistakes or in its rights. It is least likely that even if the judges were to write the individual decisions, a different outcome will have been forthcoming. But that said and done, there are some in our midst who have held that the Supreme Court is the most pliable of all the courts, because often when the High Court makes a very fundamental declaration of matter of rights and freedoms, when the Court of Appeal affirms it, the Supreme Court just dislodges it with an argument that doesn't seem to resonate with logic, let alone the law. So it looks like it's a wasted court. In fact, there's discussion rife in the lawyers' forums. Do we really need the Supreme Court?
Okay, we'll talk about the principle of public participation as well, because it's a key component in our governance structure and our constitutional democracy. Senator Eddie, okay, it's certainly a big win for the government given what happened to the Finance Bill of 2024. But what is your reading of the outcome and the determination made by the top court yesterday?
Thank you, Ayub. I think that we have a very big challenge as a country because most of the things that happen in the executive and most of the things that happens in the legislature are eventually, exposing the rift between the understanding of the two bodies and the judiciary around the constitutionality issues. Now, the way our constitution is framed is in such a way that issues constitutional interpretation is a very difficult thing that the National Assembly or the Senate and the executive might not be able to eventually be able to give a firm decision on, and therefore that's why the judiciary was created, so that the judiciary can be able to help us as a nation to be able to interpret issues constitutionality. And what happened with Finance Bill 2023, because I was actually a co-petitioner with Okia Mtata on this, is the interpretation around overarching issues of constitutional interpretation. Now, the decision, despite the fact that it endorses Finance Bill 2023, there is also an interpretation of the Constitution that it now brings into place in terms of things like what is the threshold for public participation. This is something that is going to wallow for long, because I did not get that from that ruling. You remember that in Finance Bill 2023, one of the contentious issues was the issue of the housing levy that was put on Kenyans. And there are a lot of questions in terms of constitutionality, again, whether the housing levy is a levy that was violating the rights of Kenyans, and whether the people who had been levied during the time of this entire contention should actually be compensated or not. So there are a lot of constitutional gap that the court did not pronounce itself to, that then leaves us as a country in what Avi has just said, a court of final mistake, to the extent that it would be very difficult if we constantly pass laws and if we constantly find ourselves in decisions made by the executive and decisions made by the legislature that have got constitutional interpretation that the court leaves us wallowing on over and over.
And Counsel Harvey, the Court of Appeal had declared the Finance Act as a whole unconstitutional, and it cited this fundamental principle, lack of public participation. And to just quote what the Supreme Court yesterday said in overturning that, it said Parliament ought to put in place a legislative framework to regulate the process of public participation as envisaged under the Constitution. And it said the House ought to be putting in place the measures to ensure that all versions of a bill at every stage of the lawmaking process are accessible to the public for their information and scrutiny. Here comes in the threshold factor, is it? And it appears that we have no clarity over how we can meet that constitutional threshold of public participation.
Absolutely. And this is where the Supreme Court turns logic over its head. It laments want of legislation as a yardstick to enable public participation. Whose failure is it to enact legislation that is required under the Constitution for purposes of public participation? It is the responsibility of the National Assembly. It is the same National Assembly that approved the bill that was brought before it by the executive. Now, if you find a failure occasioned by a party, do you then sanitize the actions of that party and say, because you didn't do this, we'll allow you to continue doing this in a wrong way? And to that extent, the Supreme Court has impaired irreparably gains hitherto made in ensuring that the dictates of the Constitution that demand people's participation at every stage of legislation. And legislation for purposes of budgeting and taxation is a very fundamental aspect that people cannot be left out. And I mean, you're tempted to ask who's bidding what they're doing, because they have identified the problem.
Yeah.
They know the source of the problem, but they permit the problem to prevail. Perhaps it is a mood that the people of Kenya need to read. If the courts cannot provide solutions to obvious problems, then what do they need to do? They need to do something.
And which is?
They've done it before. They ensured that the Finance Bill 2024 did not see to its fruition. And I've always said this, many people may not agree, but I adopt what I call trial by combat. By the time my case reaches the court, the judge has understood it, the judge's wife has understood it, the judge's children know it. They will be telling the judge, look, did you see that case? Because you can't do these things in secrecy. And Eddie, going forward, you and Okiya Mtata must adopt trial by combat. You need the people to sail with you in your litigation, because the path of law is towards engineering the society. And the more the public pull or push there is, judges will be minded not only to do what is right under the law, but to do what is right and just to the people.
Yeah, and we'll talk more about that aspect of how then we can drive this conversation forward in regards to an emboldened citizenry who is well aware of what's happening in their country and given what transpired in Parliament on June 25. But Eddie, in essence, when you look at the determination which was made by the Court of Appeal yesterday, overturned by the Supreme Court, in between do you read a failure in comprehending and understanding the national mood at the moment?
I don't think that that the national mood should sometimes dictate the courts. I think that the court just needs to be competent. It's an issue of competency. Because at the level of Court of Appeal, the decisions that are made at the Court of Appeal, my humble understanding would be that at the time that a Court of Appeal makes a decision, there should be some semblance of congruence, at least, if not in all the decisions that are made by Court of Appeal, then at least a majority of the decisions of the Court of Appeal. Because the Court of Appeal judges, the way our constitution is structured, the supremacy of the Supreme Court is to the extent that most of the problems that we're dealing with of constitutionality should be able to be dealt with by the Court of Appeal. One fundamental question that even if you look at it from the perspective of government and you want to be a sympathizer of how government should run, one question that you'd ask yourself, where we find ourselves with Okiya Mtata and myself, is that should a country operate without a finance bill? It is a fundamental question to the extent that it influences service delivery, it influences tax collection, it dictates the mood of the nation in terms of economic quagmires that the country finds itself when a finance bill is struggling. So that when we go to courts to get not just an interpretation and a solution that my brother Avi has talked about, but the idea of time is critical. To the extent that when this finance bill was pronounced on by the Court of Appeal at that level, you would expect that because of competency issues, the Supreme Court will take a quick turnaround to be able to pronounce itself on this. So we are seeing two things that are emanating from our courts. Either, one, an issue of incompetency among our judges, or an issue of complacency, where the courts have become activist platforms and political platforms that they're not making judicious decisions. And I think that we need to encourage our courts to have the boldness to make what makes sense in terms of law.
But when you mention that, and the question of, I'll come to you, Council, as well, you have a point, I know that, is can then manage ourselves without a finance bill, which basically is the money bill, because this act in essence will be fetching, as per the plan at the time, 311 billion Kenya shillings, inclusive of the housing levy. Because if you look at this plus the deficit and the grants that we'll be talking about and some of the proposals that were contained in the act, clearly this is a conversation that then again takes deviation away from where we are at the moment to sealing, for example, graft loopholes where a lot of money is lost. And this, according to the Controller of Budget and advice from the Parliamentary Budget Office, who are all concerned about other issues that, if fixed, can then allow the country to run smoothly in terms of managing its economy.
Yeah, the truth is that after the decision of the Supreme Court, because that is the court of final resort right now, final mistake according to Harvey. But after this, then the conversation then must go in terms of issues of accountability, right? For instance, if the housing levy is entrenched because of this decision, then can we be able to put an accountability law and accountability framework to ensure that the houses are actually built? And can we also be able to ensure that that housing levy does not constantly give burden to Kenyans, right? So there are going to be a number of indices that then must be put in place to ensure that all the factors that were put in that finance bill are now put to the test of corruption and avoiding graft, as well as ensuring that the government can actually perform according to that bill. But remember, even as we speak about Finance Bill 2023, it is just a fallback plan because we had Finance Bill 2024 that already collapsed. And this bill, even though it is its legality has been enshrined by the Supreme Court, we ought not to be using it because the projection of government currently and the subsequent bills that have been passed in National Assembly and the Senate, including things like the appropriation bills that have been passed after, are pegged on Finance Bill 2024. So even though it is a fallback plan for government to be able to use to raise resources, it is not the most updated bill, and therefore its legality is still questionable.
Mm-hmm. Yes, Councillor, you had a point.
Yeah, just to pick up from where Senator Eddie Okeche has said, you know, this administration is running fast after a speeding conveyor belt. It doesn't seem to be catching up. And you raise a very fundamental question. What is the fate of the financial probity of a government in the absence of a Finance Act? Ideally, it must be understood that taxes are being collected, expenditures are being made. The only problem is that they're not regulated because the Act is the instrument through which that regulation is done. And this is a scenario that ought not prevail longer than necessary. And to that extent, there is malafides in the manner in which this administration is handling this matter. And the courts, the Supreme Court, as the apex court, has not helped. It has not helped. How I wish our legislators will be more proactive. And Eddie, as we discuss this, please take this discussion to the House and ensure that the necessary legislative pillars that are required are put in place.
Yeah.
But I just want to mention to my brother Avi that at the house where I sit, and this is not an excuse for mischief in any case, at the house where I sit, finance bills, you know, don't get to us as much as they should. But I think that the sobriety in the Senate, given that it's a smaller house in terms of the number of legislatures that are there, I think that the framers of the Constitution did a very big disservice to Kenyans by making sure that finance bills don't come to the Senate. Because I think that one of the biggest challenges that Kenya is facing is that once finance bill and finance bills in general have been examined and passed in the National Assembly, it becomes a final resort in terms of legislative process. And I think that the gaps that we are seeing, if we ever have constitutional amendment conversations in the future, one of the areas that the country must be able to think about and rethink is the issue of finance bills ending at the National Assembly.
Origination and ending there.
Yes, okay. They must originate from the National Assembly, but they must end at the Senate, because that's sobriety in terms of, because some of these things is about scrutiny, really. And the scrutiny at the High Court is pegged on evidence that has been brought before them. So the decision at the High Court already, or actually all courts, the decision is only pegged at the evidence adduced at the courts. But at a legislative process like the Senate, that's why you see that the sobriety in the Senate is very high, the scrutiny of bills is not only pegged on evidence, but also on interaction by the populace, because it's a political process that enables the Senate to be able to engage the people. That's a bigger gap that has caused us this problem.
Yeah, and Council Harvey, given what we had witnessed, I want to extensively talk about public participation and the understanding by members of parliament themselves in getting or comprehending the contents of what was contained in that bill, now an act because of the Supreme Court ruling, and how they themselves who voted for the same bill, which is now an act, again reneged, saying, no, this is punishing our people, it's punitive, and I'll be having some samples quotation. But given that, it seems that Parliament at the right time is always dead against the submissions made by the public. In this case, the Finance Act of 2023, when the public made their submissions before the committee chaired by Kuria Kimani, the lawmaker from Molo, and more than 900 people sent in their proposals, and the report in the final never captured that. And the Supreme Court now says Parliament ought to have a way to regulate that. I mean, how can this happen then? If the people say we want this, Parliament is dead against that, and there's this now guidance from the Supreme Court to Parliament, the very same house that Kenyans are concerned about its conduct and how it's going about its affairs.
Two things. The Supreme Court is wrong, and we must call it out. It cannot adopt the Dugdalean approach. The Dugdalean approach was the approach where Justice Dugdale refused to enforce the Bill of Rights, freedoms and fundamental rights, because according to him, the Chief Justice had not put in place rules. So here you are saying Parliament has not passed legislation to facilitate public participation. If that is the case, then anything that Parliament does that required public participation is null and void, and just declare it as much. That's number one. Number two, Parliament itself, the individual members of parliaments are very pendulamic in their approach. At one particular point in time, they will say this is right and this is wrong. Why do they do that? I believe to a large extent, a majority of members of parliament are driven by their own personal interests that tend to shift from one goal to another goal, from 1 minute to another minute. And if you look at page 10, and you will forgive me when I appear here and I always pick page 10 of the Standard.
Because it's the cartoon edition.
It's the cartoon edition. And this is my friend, I think it's Opondo Kaluma. Some people say that we look alike. Maybe that's why I'm able to identify him. So look at the left side. It says, we have to speak truth to power. That was then. They were exercising their role as opposition. Mm-hmm. Now, when they are in what many people call the bread-based government, this is what they say now. We have the power, so why speak truth? Ideally, that is the pendulamic theory of a majority of our legislators. It is the Achilles heel that has brought us to where we are.
And getting back to the ruling by the Supreme Court, and still on your counsel, because if you put that vis-a-vis what has transpired since the impeachment process against Rigathi Gachagua kick-started, for example, 224 Kenyans had volunteered to give their views in the impeachment process as a whole. And here the top court says Parliament ought to put in place a legislative framework to regulate the process of public participation as envisaged under the Constitution, and that the House must make sure that all versions of a bill at every stage of the lawmaking process are accessible to the public for their information and scrutiny. Then this certainly is a political process. I mean, the argument can be that millions of Kenyans took part in the elections. Then the threshold question comes in here, Council. How then can this be undertaken given where we are at the moment, and this bill is still at the advisory stage with the Attorney General's office? I mean, how can this be entirely undertaken? Because going ahead, there's going to be the Finance Bill of 2025, and Kenyans will come out to give their submissions and views, which may not be considered by the House given its conduct up until now.
You know, to a large extent, we must admit that Parliament is not a lazy arm of government. Why do I say so? Where there is need for Parliament to pass legislation speedily and effectively, they will do it in a record 2 weeks, 1 month. They've done it. Where there is need for Parliament to take a policy or oversight decision within a short period of time, they have been able to do it. Then what explanation can be given for the failure to enact the Public Participation Act? No justification whatsoever. What we can surmise is that there is a desire, ostensibly not within Parliament, perhaps outside Parliament, the executive, to have this issue unclear so that it may be utilized as and when there is need to push an agenda without lack of clarity on what entails public participation. But when this is said and done, there is a plethora of decisions by the High Court and the Court of Appeal. And for these purposes, let's look at the law from the High Court and the Court of Appeal, and not the Supreme Court, on what public participation entails. And ideally, the framers of the Constitution had a lot of foresight. They must have projected a scenario where the delegates, the representatives of the people in the National Assembly and the Senate, will run rogue. And for that reason, they cushioned the pathway with the provision for public participation so that every stage of what legislators are doing will be supervised by the people. And so transformative is the Kenyan Constitution that it is uncomparable to any other constitution because of what we'd gone through before. So I think going forward, we must be very deliberate insofar as this public participation is concerned, because it will bedevil every activity that is undertaken by Parliament, by the executive. And you alluded to the problem that is current.
Yeah.
What if the High Court, now constituted of 3 judges, says that, fine, we are not satisfied with the level of public participation in the removal of Rigathi Gachagua as Deputy President, but to the extent that there is no legislation to govern it, we will let it go. And we cite the decision of the Supreme Court as authority for action. You now begin to see the dilemma.
And still come back to the
Supreme Court as authority for action. You now begin to see the dilemma.
And still come back to Parliament, is it? Because critically, it's an institution that is equally placed strategically between the power donators and those who exercise that power. And at the fulcrum is this House of Representatives, our parliamentarians who ought to be checking over all these matters. But again, the main question would be, and fundamentally so, why has this been pending before them? Yeah,
and see, the inertia, the inaction is this. The expectation was Parliament will do right. And as it does right, and sometimes does wrong, the people's oversight will always be there to maintain vigil, to ensure that the path is straight. And who is to assist the people in this enterprise? It is the courts. And when the courts at the apex level, the Supreme Court, fail to do the necessary thing, then it is an admission that the courts are helpless to undertake a very fundamental role that is given to them by the Constitution. That's a big failing of administration.
And largely because we'll be talking more about that, Councillor Harvey and Senator Eddie Oketch, because it's fundamentally important we highlight the relevance of Parliament. And when we get back from the break, Senator, we'll proceed as well as what you said on Sunday when you attended a church service with the President in Moiben constituency in the county of Uasin Gishu, and as well as the concerns expressed by the American government over the loss of privacy and the rule of law around rights of private citizens and the need for that to be respected according to its ambassador here in Kenya, Meg Whitman. All that after the break here on The Break. Stay tuned.